Applying the law to real-world brokerage decisions. As we continue building on supervision, licensing, and compensation, this section shifts into real-world legal scenarios that brokers and agents encounter every day. Understanding statutes is critical, but knowing how to apply them in real situations is what separates an average agent from a highly skilled professional. Each of these scenarios ties directly back to earlier sections, reinforcing that supervision, risk management, and compliance must be practiced, not just understood. Pre-possession agreements, high risk, high responsibility. A common situation arises when a buyer wants possession of a property before the close of escrow. While a listing agent may assist in preparing a pre-possession agreement, Arizona law requires that the agent recommend that the parties seek professional advice from legal, insurance, tax, and accounting experts. This requirement comes from AAC R428-1101K, emphasizing the agent's duty to protect clients from unnecessary risk. Pre-possession creates potential liability issues involving insurance coverage, damage, and contractual disputes. A strong broker will ensure that agents understand that facilitating the agreement is allowed, but failing to advise properly can lead to serious consequences. Bankruptcy disclosure, knowing what must be reported. Another area of confusion is whether agents must report personal bankruptcy to the Arizona Department of Real Estate. The answer is no. Arizona law requires reporting of convictions, disciplinary actions, or restrictions on professional licenses, but not personal bankruptcy. This distinction highlights an important compliance principle. Not everything negative must be reported, but specific legal triggers must be reported immediately. Ownership of a brokerage, licensing versus control. A non-licensed individual may own a real estate brokerage entity, provided that the entity itself is licensed and has a designated broker responsible for operations. This reinforces a recurring theme. Control and supervision must always rest with a licensed broker, even if ownership includes non-licensees. This is particularly important in team structures, partnerships, and investment-backed brokerages. Backup offers. Following the seller's instructions. When a backup offer is received during escrow, the listing broker must first present the offer to the seller. After that, the broker must follow the seller's instructions regarding disclosure to the buyer. This ties directly to fiduciary duty under AAC R428-1101. The broker's duty is always to the client, not to the transaction itself. Commission payments, understanding exceptions to the rule. While ARS Paragraph 32-2155 generally requires commissions to flow through the broker, there are limited exceptions. A broker may assign commission payments directly to an agent under certain circumstances, including escrow disbursement at closing or payment to an estate or bankruptcy trustee. However, these exceptions must be handled carefully and documented properly. This reinforces a key concept. Exceptions exist, but they do not eliminate the need for compliance. Deductions from commissions. Broker rights and limitations. If a broker incurs expenses on behalf of an agent, such as paying a judgment, the broker may be able to deduct those costs from the agent's commission under ARS, paragraph 23-352. This is why employment agreements are critical. A well-drafted agreement clearly outlines these rights, reducing disputes and protecting the brokerage. Do not call rules. Marketing compliance still applies. Even if a seller lists their property publicly, such as on a FSBO website, brokers cannot contact them if they are on the Do Not Call registry unless an exception applies. This reinforces the importance of marketing compliance covered earlier. Just because information is public does not mean solicitation is allowed. Attorney involvement, confirming representation. If an attorney claims to represent a client, the broker should confirm this directly with the client. The broker's fiduciary duty requires clear communication and written confirmation of representation. This situation highlights the importance of communication and documentation. Assumptions can lead to liability, but verification protects the broker. How this section connects. Forward. This section brings together everything we've covered so far, supervision, compensation, agency, and compliance, into real-world decision-making. These scenarios demonstrate that most violations do not come from lack of knowledge, but from poor judgment or lack of systems. As we move forward, we will continue focusing on risk management strategies that prevent these situations from escalating into disciplinary action. Online discussion. Question 1. Why are pre-possession agreements considered high risk? Answer: because they create liability issues related to insurance, damage, and legal responsibility, requiring agents to recommend professional advice under AAC R4 28 111 and 01K. Question 2. Why must backup offers be presented to the seller? Answer: because the broker has a fiduciary duty to the seller to present all offers and follow the seller's instructions regarding disclosure. Question 3. Why is documentation critical in legal scenarios? Answer: because proper documentation protects the broker and ensures compliance with Arizona law, reducing the risk of disputes and disciplinary action.